Welcome to LFPL's At the Library series, an ongoing podcast featuring author talks, programs, and events at the Louisville Free Public Library. For more information about upcoming events, visit us online at www.lfpl.org/upcoming-events.htm.
Tonight's guest is a civil rights lawyer, writer, speaker, activist, and a professor at the University of Louisville School of Law. He has argued before the Sixth and Seventh Circuit Courts of Appeals, the Kentucky Court of Appeals, and the Kentucky Supreme Court, and he is perhaps best known as lead counsel for the Kentucky plaintiffs in the landmark Supreme Court case which brought marriage equality to all 50 states. Please join me in welcoming Dan Canon.
Thanks, everybody. I've seen a lot of people that I've only seen like through screens for the last 2 years, and sometimes only through screens. So this is very exciting to have an in-person event. Let's enjoy it while we can. Yay! So enormous thank yous to Paul and to Beth and Susan at Carmichael's especially, who have all just been amazingly supportive and are always amazingly supportive of local authors, and then my team at Basic Books, just a great publisher, and has been just awesome throughout this whole thing. And I'd be remiss in not thanking all of them by name, but I can't remember all that, and I don't have it written down. I have a stack of notes here. And when I was talking to Paul about what the format was going to be tonight, he's like, well, you just go up and sort of talk about plea bargaining for 45 minutes. And I'm like, Paul, I can't talk about plea bargaining for 45 minutes. Like my minimum talk for criminal justice is 5 hours. So like, you got to get people who are really committed to come to the library and listen to this talk, because if they're not in for 5 hours. So I will try not to be too canned as I refer to these notes, but my students will tell you that I have a tendency to just sort of ramble and get off track and rant and rave as I talk about this stuff. So I'm going to try to use this to keep me in line. And I think a perfectly good question, if you're thinking about buying the book or if you've already bought the book, is, why would I want to read a whole book about plea bargaining? There's a whole lot going on in the world, and not a lot of time, and 300 pages of plea bargaining seems kind of boring. Well, okay, I heard someplace that when you're doing public speaking, you should do things in threes. So, 3 reasons why you should pick up the book. First, plea bargaining is a good way to understand everything that is wrong with the American criminal justice system, which is a lot. We arrest and convict and incarcerate far more people than any country in the history of the world, which I expect most of you know. And that's both in terms of the percentage of the population and just in raw numbers. And when you look at that situation, you have to either believe that Americans are just more predisposed to criminal behavior because of violent video games or marijuana or too much sex on TV or whatever, or you can assume that there's something else going on. And what I'm saying in the book is that the plea bargaining piece of what we do is the something else, which kind of makes sense if you think about it, because you wouldn't have these astronomical numbers. You couldn't have these astronomical numbers of justice-involved people, of incarcerated people, without a method of getting lots of convictions really quickly. And that's essentially what a plea bargain is. And you'll also note that no other country has the kind of criminal justice outcomes that we do. No other country uses plea bargaining the way that we do. And you can read the book and decide whether or not you think that's just a coincidence. I don't. The second reason that you ought to pick up the book is that it gives practical ideas of what we can do together to fix the monstrosity of a criminal justice system that we've ended up with. And because the thread of plea bargaining runs through every aspect of the criminal justice system and is the chief enabler of a whole lot of bad things, if we all tug on that thread a little bit, my hope is that a lot of those problems could start to unravel, and I'll explain that some more later on. The third reason is that you should pick up the book, is that you can trust me. I give advice for a living, and I have elbow patches. You can trust a guy with elbow patches, and I'm telling you that it's a pretty entertaining book as far as criminal justice books go. It's not, a collection of David Sedaris essays or anything like that, but it's not dry or boring. I've tried not to make it too dry and boring. It's certainly not just for lawyers. And I think you'll like it if you like reading about the terrible things that human beings do to each other. And it turns out that many of us do, especially if there's some sort of hopeful message at the end of it that we can sort of squeeze out of all the stories of misery and suffering. Speaking of misery and suffering, I'm going to read to you a little passage from the book. Page 19. You are to be drawn upon a hurdle to the place of execution, and there you are to be hanged by the neck, and being alive, cut down, and your privy member to be cut off, and your bowels to be taken out of your belly, and there burned, you being alive, and your head to be cut off, and your body to be divided into 4 quarters, and that your head and quarters be disposed of where his majesty shall think fit. I did not write that. That is a statute, a criminal statute that was on the books in England for a little over 500 years. It was a penalty for treason. And England was putting a lot of terribly harsh laws into place around the end of the 1600s. And those were designed to essentially to scare the working classes and scare the poor into submission. So everything was a felony, and all the felonies carried the death penalty, and the death penalty was always, the result of some gruesome and horrible torture. So in the middle of the 18th century, around the same time as the British Industrial Revolution, the British developed this practice of leniency. And what leniency meant was that if you got a death sentence, you could go to the crown and say, look, I'm really sorry for what I did. I'm very contrite. Please don't kill me. And the king would say, all right, well, we won't kill you this time. And that got to be in such wide use that by 1819, only 97 people were put to death in England out of more than 1,200 who had received death sentences. So enormously popular policy. And this wasn't some newfound devotion to kindness and human rights that had suddenly cropped up in Victorian British society, but it was because elites at the time were grossly outnumbered, aware of being grossly outnumbered by increasingly class-conscious workers. And they recognized that they needed to respond and adapt if they were going to maintain their place in the social hierarchy. They couldn't just like whack everything over the head with the criminal law. They couldn't torture and kill everybody that broke the law because that would create some unrest, and they were horribly outnumbered. So the practice of leniency, the purpose of that was to improve social ties between classes, and it made the lower classes think, oh, well, actually, the monarchy is not that bad because they didn't kill me. And it made people think that they had a role to play in the criminal process, in the adjudication of crimes, because they could say, oh, I begged for mercy, and I was very contrite. And the crown listened, and look at the role that I played in my own fate and in my own destiny. So it sort of disguised the classist bent of the whole system to have this procedure in place that would get you off the hook. Why does any of that matter to American plea bargaining? Well, let's look at what was going on in the United States at the time plea bargaining started. And we think, as best as we can tell, that the first plea bargains happened in Boston in the 1830s. And at that time, you've got a laboring class, landless laborers that were becoming a very large percentage of the population in and around New England. In Boston alone, the population shot up by 51% just in the 1830s. And so there's this influx of European immigrants, there's this influx of migrant workers coming from all over the country to work in the mills post-industrial revolution in New England. And those workers are forming communities, and they're living right on top of each other, and they're talking to each other, and they're developing class consciousness. And that was not great for the ruling classes in New England. In 1834, you've got the first federation of labor unions that forms in New York. And these folks are looking around saying, we might be in a little bit of trouble here. At that time, white male suffrage had become the new norm and was almost universal in the United States by 1830. So that meant that the working class, non-landed white men could vote and serve on juries. So the elites in New England at that time look at that, and these are people who essentially looked at class as a birthright. That's the way they thought about class. Not some sort of like mobile thing, right? Not a thing that you could jump from one class to another. It's just you're born into this class, and that's where you stay. And just like the elites in Old England, the elites in New England are saying, well, this is bad, and we've got to do something about this if we want to maintain our place in the pecking order. The legal system at that time, and in fact, most institutions of government, was devoted to actively and openly trying to break the back of organized labor at that time. So the nascent labor movement was a huge threat to the social order of the time. And so they were really trying to do away with it. And the way they were doing it primarily through the courts was by criminalizing organizing, right? So you prosecute a group of workers for getting together and demanding higher wages under a conspiracy statute or something like that. So they would grab them for conspiracy for making what they called combinations of workers. Well, that wasn't going to work for very long. Because now you've got working class people on the juries, and they're pretty sympathetic to workers that are getting prosecuted for conspiracy. And there are just so many of them now, and there's not enough police power to stop them from organizing outright and still maintain legitimacy. And the courts finally give up that strategy, in Massachusetts at least, around the early 1840s. They finally say, okay, well, you can organize within certain parameters, and we're not going to prosecute you all for conspiracy because that's simply not going to work. To make up for that, the ruling classes used the courts in two really important ways. And one was to take power away from juries. So the jury at that point in time was this enormously powerful thing. I mean, juries are powerful now. We just don't have that many of them. But at the time, they were even more powerful. This is a thing that I didn't really realize until I started researching for the book. You know, how juries now will decide issues of fact, right? So did somebody run the red light? Did the car run the red light? That's what the jury is confined to having to decide. Well, back then, it was more of a thing of not only would you decide issues of fact, but also issues of law. So was it illegal to run the red light? Not a great example when we're talking about the 19th century, but you get what I'm saying, right? So they're deciding issues of law and issues of fact, and that made the jury enormously powerful. And now all of a sudden you've got a bunch of working class folks, you know, just normal, unwashed slobs with callous hands and whatnot, sitting in jury boxes. And they're like, okay, well, we got to do something about that. So that power got taken away. The power to decide issues of law actually got taken away from juries in Massachusetts around the 1850s, right? And that was enormously controversial at the time. Like I've got a section in there. This is more interesting than it sounds, I promise. But I got a section in there from the Constitutional Convention of, I think it's 1853, where there's this fierce debate over what should juries get to decide. We take it for granted now. The jury's the fact finder. You know, they don't say what the law is, they say what the facts are. But that was a big controversial issue. So at that time, they decided, well, all right, we're going to yank that power away from juries, and we're also going to courts start restricting the kind of evidence that juries can hear, right? And making it super complicated and inaccessible for the working classes to sit on juries and have any idea what's going on. The other legal tactic that the ruling classes started using around the same time is the plea bargain. And the rate at which plea bargaining took over criminal justice in Massachusetts after its introduction is astonishing. There is no record of plea bargain cases before the 1830s in Massachusetts. And we know, actually, that prosecutors who were offering deals to defendants in Massachusetts in the 1840s were getting prosecuted for it. So it was illegal, it was taboo, it was anathema to the whole idea of justice at that time. Well, by 1850, more than half of all criminal cases in Boston were disposed of by guilty pleas. And by 1880, you've got almost 90% of all criminal cases disposed of by a guilty plea. So it goes from being this thing that's illegal to being the norm in Massachusetts in almost no time. And to understand why that happened, we have to ask why the plea bargain might have been useful for maintaining the social status quo. Well, for one thing, plea bargains exclude juries. And for those of you who don't know how this works, essentially the way a plea bargain happens is the lawyers go into a conference room and they work something out and they bring it back to the judge and they say, this is what we came up with. And the judge almost always signs off on it, and no jury ever looks at it, no higher court ever sees it because the defendant made a deal, you don't appeal it. And the public usually doesn't know or care what happened with that case. What were the parameters of the negotiation? Well, we don't know, we don't care. And much like the practice in England of leniency, this made people feel like they had some skin in the game, right? Because it's not just crashing somebody over the head with the criminal law. It's saying, you bargained for this. Look at this contract you made with the state. This is what judges say about this over the last century, right? Well, this is a contract with the state. So it's just like buying a used car or hiring somebody to fix your toilet or something like that, right? These parties of equal negotiating power got together and figured out what was going to happen to the rest of this poor fool's life, right? So you can see that at the same time that juries are taken out of the equation, plea bargaining starts taking over, unionizing becomes legitimized through the courts, and the criminal law in America starts to expand enormously, right? Rather than criminalizing organized labor outright, the ruling classes switch to a tactic of saying, well, let's criminalize lots of individual behaviors that workers are involved in. And the prohibition movement starts in earnest in the 1830s. And you've got this huge swelling of the criminal code, especially in the 20th century. And by the time you hit national prohibition in 1919, well, that's a watershed moment, because then the feds get involved in all this day-to-day criminal enforcement that they weren't really involved in before that. And Congress gets in on the act, and they're like, yeah, let's criminalize everything, because everything has something to do with drinking, right? So, and I've got a bit in there from Herbert Hoover's inaugural address, and it's apparent by then that expediency is the guiding principle of the criminal justice system, because look, we've got a lot of people to lock up. There's just a lot of crime and a lot of people to lock up. And he says in there, he's like, well, it's not just the bootleggers, but it's the people who are assisting the bootleggers and the people who are assisting the people who are assisting the bootleggers. My God, everybody could be a criminal. And that pretty much is the guiding philosophy that we've taken all the way through the 20th century and still retain today. The year after Prohibition goes away, that's 1934, Congress is like, well, what are we going to do? We got all these enforcement powers, and we've built all these prisons. In fact, the federal prison population, by the way, shot up 3 times. It tripled between 1920 and 1933 under Prohibition. So we've got all these enforcement capabilities, and we've got all these toys, but we don't have any games to play. And so they passed in 1934 9 different federal crime bills criminalizing everything under the sun, and Congress doesn't even know how many criminal laws there are. They actually have formed task forces to figure out how many criminal laws there are, how many federal criminal laws there are. So that's sort of where we are today, because then you get into the post-Jim Crow era where white America is going crazy, locking up people of color. You got the drug wars, you got the rise of criminal penalties that are associated with the administrative state, so intent is really no longer required for a lot of crimes, but for the first time, like really ever in human history, really. And here we are in the late 20th century, or there we were in the late 20th century, where damn near everything you do can be considered criminal in some way, and those criminal penalties have continued to increase today. But all the way through the 20th century, plea bargaining is becoming more and more popular over the country. All over the country, even in places that resisted it till the very end of the 19th century. Because you just can't prosecute all that crime without a quick fix. You can't go to trial on every case. It takes too much time, and you need something to streamline the process if you're going to catch all those criminals. So, lawyers and law professors and even judges are struggling with this state of affairs throughout the 20th century because it feels wrong, right? It kind of feels wrong. I mean, if you don't have a lot of experience with the justice system and you just know what plea bargaining is, most people are kind of like, that doesn't feel quite right. And the academy and judges were struggling with this too, clear up until the late 1970s. Especially with the issue of how much power do we really want to give prosecutors to negotiate these things. Well, in 1978, the Supreme Court answers that question. They decide this case called Bordenkircher versus Hayes. It's a Kentucky case. And this guy, Paul Hayes, is a 29-year-old black horse transporter in Lexington. And he gets caught writing a bad check at a grocery store for $88.30. And he gets arrested, and the prosecutor comes to him and says, listen, you've been in some trouble with the law before, haven't you? Well, you're going to take 5 years on this $88.30 check. You're going to go away for 5 years. The guy's like, well, I got a job, and I got a family, I got all this other stuff. I can't go away for 5 years for a $90 check. I don't want to do that. Like, well, if you don't do that, Mr. Hayes, what's going to happen is I'm going to hit you. If you put me through the inconvenience of a trial, this is the prosecutor's words, put me through the inconvenience of a trial, and I'm going to hit you with the state habitual offender statute, what we might call like a PFO now. And the habitual offender statute carries a mandatory penalty of life in prison. So you're playing for either 5 years, if you take my deal, or you gamble with the jury and you get the rest of your life. And, I guess Mr. Hayes is either profoundly brave or profoundly stupid. And I've read the whole trial transcript, and I think he's profoundly brave. And he says, no, I'm not doing it. I'll take my chances with the jury. 5 years, I'm not taking 5 years. And I don't think they're going to give me life. Well, he gets convicted, and he gets sentenced to life. It takes the case all the way up to the United States Supreme Court. And the Supreme Court says, well, the prosecutor's job is to persuade someone to give up their right to trial. And Mr. Hayes wasn't persuaded, so tough luck. You do a life sentence for an $88 check. And the prosecutor gets to use whatever's in their bag of tricks to get you to give up that right to go to trial. Now, this is what sets us apart from the rest of the world, the rest of common law countries at least. Now, the Hayes case is not, I don't think is all that well known. I don't think it's taught that much. Joe, do you teach? You don't teach Bordenkircher, yeah. Got some teachers in the audience. But I think it's a pivotal point in American history because that is the case that really throws open the floodgates for prosecutors to do whatever it takes to get someone to plead. And I talked in the course of writing this book, I talked to Vince April. And some of you may know Vince. Vince still practices here in Louisville, and he represented Paul Hayes at the Supreme Court. And he also did Paul's parole application. And in the parole application, he included all these letters that he had gotten from prosecutors all over the country saying, "This is outrageous. We would never do anything like that. How could somebody do that? Impose a trial penalty? Penalize somebody just for saying that they wanted to take something to trial? That is just, I would never do that." I don't know if those prosecutors were telling the truth. And I think probably some of them were at the time. I have no reason to believe otherwise. But it's certainly not true now, right? This is the norm. This is how it works now. Everybody knows that. Everybody knows that. For two generations of lawyers have gone to court knowing the prosecutor can do whatever they want. They can threaten somebody with higher charges or infinite jail time, or they can offer lower charges and no jail time to secure a conviction to get a case over with. That's how it works. You can even let somebody plead, a judge and a prosecutor can let somebody take a plea if they maintain factual innocence. And that's like a normal thing for lawyers. It's an Alford plea, right? But think about that. That's perverse. You know, to stand up in front of a judge and say, "Yeah, I didn't do it, but I'm still going to plead guilty." Okay, great. You know, what? But that's a norm of our justice system. And the lawyers are out there going, "Oh, what's wrong with that?" And prosecutors, we're at a place where prosecutors can and do even threaten people with death quite frequently. It's very common to do that. One of the more terrifying statistics in the book, and there are a lot of terrifying statistics, is that 75% of the defendants who have been executed since 1976 could have avoided the death sentence by taking a plea offer. That is an astounding statistic if you think about it, because that means if those folks had taken a plea, the prosecutor wouldn't have sought the death penalty at all. So, I think most of us think that if you're innocent, you're less likely to take a plea to something that you didn't do. And if you don't take a plea, you're more likely to get the death penalty. So innocent people, if they are wrongfully convicted, are more likely to be executed. And that, to me, is chilling. It's a fact that we accept about our criminal justice system for whatever reason, but I think it's terrifying. Even if you don't like the death penalty, and I don't, we still sleep a little easier as Americans at night, I think, thinking that, well, we only put the worst of the worst people to death. They probably did commit some gruesome or heinous murder, and that's why they're on death row in the first place. I don't know, folks. The point is, since prosecutors can use whatever carrots and whatever sticks they want to make sure people plead, the result is that 97% right now, and rising, of all cases end in a guilty plea. So somewhere around 3% of all cases are actually resolved at trial. The jury trial is effectively dead, and that means that the public, the community, is effectively totally removed from the process of criminal justice. And a big part of what I'm arguing in this book is that the extraction of the community from the criminal justice system has caused incalculable damage to our society. And for one thing, we don't see some of the outrageous punishments that prosecutors and sometimes judges come up with in order to get reduced sentences for defendants who would rather not spend more time in prison. So people are ordered not to reproduce. That happens all the time. Thou shalt not reproduce. No more kids. You get smacked for felony child support. Well, I could send you to prison for a couple of years, but actually, why don't you just, I'll send you to jail for 6 months, and you're going to agree not to have any more kids until all your child support obligations are paid off. And that's like, what? But that happens every day. It happens a lot. Women have had tubal ligations as part of plea deals. I found one case from 1999 where a man agreed to be surgically castrated, like have his testicles removed as part of a plea deal? And who appeals that? I mean, the ACLU, this is only a thing that we know about in the public sphere because the ACLU said this is too outrageous and we're gonna file a case. And the Supreme Court of Arkansas says, well, you don't have a case because you don't have a client. He agreed to it, right? So nothing you can do about that. People are ordered to carry signs in public that say how stupid they are for the crime that they did. One man was ordered to spend a month in a doghouse, living in a doghouse. There was no dog living in it. He had to just be there by himself. One man was ordered to spank his 14-year-old stepdaughter in open court. Numerous people, hundreds, probably thousands of people actually, have been ordered to go to church as part of a plea deal. That's almost, that's actually a really common occurrence. But if you go to church every Sunday for X amount of time, I won't lock you up. But if you stop going to church and I hear about it, well, you're going right in the hoosgow. It sounds like Andy Griffith, And these aren't constitutionally sound punishments, of course, and a jury can't ever sentence someone to these sorts of things, but because they happen as part of a plea bargain, as part of this contract between equal parties, we're okay with it. Another way in which the death of the jury trial has harmed us very badly, I think, is that since police know that almost every arrest they make is going to end up in some kind of plea to some sort of something, they know they won't have to testify and present evidence and be put under a microscope for anything they did throughout the course of an investigation, right? And therefore, they know they can get away with just about anything that they want. And so they do. They lie and they falsify evidence and they violate the Constitution 6 ways from Sunday. And this is part of, like if you're working in criminal justice every day, you know this, right? Because they know they're never going to get called out for it. Everybody pleads. Everything ends in a plea. You're very rarely going to get put on the stand and raked over the coals by an aggressive defense attorney, because most of the time, and if you do, there won't be any accountability anyway. That's a whole separate thing. Now, all that is bad, of course, but it actually gets worse because there's a bit in the book about the participation theory of democracy. And the idea behind that is that the more you deliberate about some civic duty that you have to do, the more you learn and care about your own community and your own democracy. And so if you go and vote, that makes you care about stuff a little bit. Maybe you've done some research on a candidate, or maybe not, or you're at least looking at some names on a sheet and ticking the boxes next to the letter that you like the best. So it's a little bit of deliberation, but jury service involves a lot of deliberation. And so when people deliberate as part of a jury, they come away with this sort of like renewed sense of civic pride and civic duty and so on and so forth. So, if you accept that theory, and there's plenty of evidence actually to suggest that you should, then the death of the jury trial is kind of like the death of democracy, as melodramatic as that sounds, or at least anything resembling an educated or engaged democracy. And sure enough, we are, in America, by and large, pulling off about a D- on our civic report cards. 2 out of every 5 Americans can't name all 3 branches of government. 1 out of every 5 Americans can't name 1 branch of government. And about 1 out of every 10 people thinks that the Constitution starts with the words, "I pledge allegiance." There's an even bigger and I think more sinister consequence of plea bargaining than anything I talked about so far, and it has to do with the ancient stigma that we attach to anyone that we've labeled a criminal. Bless you. So let's go back to the 1830s. And we said at that time, when the plea bargain was introduced, the ruling classes were engaged in trying to figure out ways to bust up the labor movement, to break up working class solidarity. How successful were they? Well, today we've got the largest criminal class in the history of the world. That's 1 out of every 3 adults that has a criminal or arrest record. A full 1/3 of the adult population. It's a lot. And the criminal class itself is nothing particularly new. There's always been this sort of sequestered group of people who are deemed criminals in a society. But what we've done is to amplify and extend the boundaries of that class in a way that the world has never seen before. So when you identify a person as a criminal, you necessarily downgrade that person's station in life, wherever and whoever they are. Whatever rung you're at on the social ladder, you can always go to a lower one by being labeled a criminal. And we don't want to hang out with criminals, right? I mean, even if you're an enlightened liberal, if you're progressive, if you care about criminal justice stuff, and you read interesting and compelling criminal justice books, even if you really care about this stuff, right, there's still like a reptile part of your brain that's kind of like, well, I don't know if I want my kids marrying a criminal. I don't know if I want to, play bridge with criminals, that kind of thing, right? So the aversion to people labeled criminals has persisted for ages, even as we've removed a lot of the moral justifications for criminal penalties, and even as the criminal label got easier and easier and easier to acquire. The psychological studies that have been done on this topic show that not only do we not want to play with criminals, but they don't want to play, period. Right? So affixing the criminal label to someone makes them more antisocial. It makes them feel worthless. It makes them withdraw from society. And it makes them more likely to engage in other criminal behaviors. So having this huge underclass of so-called criminals disrupts broad-based solidarity among the working classes by having an enormous subset of working class people who are alienated from the remaining 2/3 of society, and in fact, from themselves. And the true genius of plea bargaining is this. I touched on it before. If a defendant insists on their own innocence and is found guilty anyway, they're most likely going to resent and reject that criminal label. But if somebody's persuaded to plead guilty, take their lumps, well, it looks like they voluntarily accepted the criminal mantle. And not only does the public believe it, because look, there it is on paper. You admitted your guilt. You said it. You said you were guilty right there. There it is. You said you're a criminal. You took on that label on your own, but defendants believe it too. They internalize it, and they behave accordingly. So just as in English leniency hundreds of years ago, you've got this trick, this sleight of hand that's performed by the state that keeps the lower classes from being too mad or particularly noticing what's happening to them. So, what do you do about all this? Well, it's conventional wisdom that if we cut back on plea bargaining, I've heard this since I started practicing, that if we do away with plea bargaining, we're going to crash the whole system. Like, that's going to be it, and it's just going to be chaos in the street and cats marrying dogs and what have you. And to an extent, I mean, maybe there's some validity to that. Right? Less than 5% of criminal cases go to trial. And if you up that to 15 or 20%, well, naturally, that requires more resources to take on that kind of caseload. More resources from everybody, right? And it does put a tremendous strain on the system, but it doesn't cause a collapse of the whole thing, at least not necessarily. And in most cases that we have as test cases for this kind of thing, what we see is that it actually forces the system to adapt. And we know this from Alaska. In Alaska, in the 1970s, they had an attorney general that was in control, and because of the way Alaska is, was in control of the whole ball of wax for the whole state, and just came into office and said, we're not going to do plea bargains anymore. And everybody was like, what? It's the way we've been doing things. No, we're not going to do it. Well, that's going to crash the whole system. It cause chaos. It did cause a whole lot more trials. But the system adapted. You have a situation in which everybody's going to trial, and the prosecutors are a lot more selective about the kind of cases that they're going to prosecute. All right? So a lot of this stuff gets screened out on the front end, and in Fairbanks, I think it was Fairbanks, maybe Juneau, someplace in Alaska, they went from a 4% rejection rate at the prosecutor's office to a 40% right after this policy was instituted, right? Because we got to be more selective about the cases we prosecute. And that, in turn, puts pressure on police to cross their T's and dot their I's and get it right. Because if cops know that their cases are more likely to get rejected, or they'll have to testify about evidence in a case, God forbid, it makes them more careful in their investigations, which is good because we want them to be less likely to arrest somebody for whatever with very little evidence. In New Orleans, same thing happened. New Orleans has had its own problems, obviously. Same thing happened. You've got a prosecutor that comes in and says, well, we're going to severely restrict the number of plea bargains. And he's doing this with the police for a long time, and they finally reach a détente. And the police are doing a better job, the prosecutors are doing a better job all the way around. And as I alluded to before, there's a potentially tremendous social value to having more people serve on juries. How many of you have ever served on a jury before, like deliberated a jury? Wow, what an engaged group. You actually went and deliberated? That's a whole heck of a lot more than you'll see in most crowds. You guys must be library goers. You must be interested in reading the latest in engaging criminal justice books. Most people don't. There was a study out of Texas that said in major metropolitan areas, fewer than 20% of people even show up when they're called for jury duty. That's not a cross-section of the community. Yeah, and if you're only 3% of cases going to trial, there just aren't that many trials to sit on. The integrated jury, my point is that we've never really tried it because the integrated jury has barely been utilized at all. If you look at the example in Massachusetts, again, women couldn't serve on juries in Massachusetts until 1950. And of course, people of color were systematically excluded from jury service long after that, and in some places still are. And if you remember, in Massachusetts, there were basically no jury trials left by the time you get around to 1950. So we haven't really tried juries of peers to administer justice. And it's hard to imagine how outcomes would be worse than what we have now if we had more jury trials. So I think that if you look at all that evidence, it looks like even a 10% increase in jury trials could potentially make a huge difference in the system. And that puts us close to where our common law cousins are at. So you look at Britain, and they have guilty pleas to about 75% of their cases. Nobody goes over 80%, and we're at 97. So I think we swing that a little bit, and we can make some big changes. Now, how do we go about getting that done? Courts are probably not going to help. This is the way they're used to doing things. And you've had these edicts from the Supreme Court come down for, 50 years now saying, prosecutors are going to do whatever they want. Plea bargaining is the way we do things in America, and that's just the way it is. Fine. Court's probably not going to help. Legislatures? I don't think so. You've seen how much good the legislature's been doing here in Kentucky or over in Indiana. And these are even folks that, criminal justice reform is a bipartisan issue. If you look at numbers, if you look at polling numbers, among the general public, and even according to what politicians say in public. And yet, what do we get in the General Assembly year after year? More criminal laws, more criminal penalties. That's what we get. Not an easing, not some way to relieve the whole situation. Even in places like California, it's super bright blue. Places where they care about, at least, the politicians say that they care about criminal justice reform. They pass stuff, but still the incarceration rate is much higher than it was in the 1970s. There's a role, I think, for judges and prosecutors, individual judges and prosecutors to play here. Elected prosecutors can make a lot of difference during the time that they're in office. Judges, you saw what Olu Stevens tried to do here a few years ago. He says, well, this jury, I don't know if you remember this, I think it was 2015, 2016, Olu Stevens says, well, this jury is not representative of the community, and so we're going to dismiss this jury and try it again. And he got smacked hard by the Kentucky Supreme Court for doing that. Profoundly brave thing to do, but I don't think that there's much that even conscientious individual judges can do about it. This is, though, one thing that individual defendants, individual people, can control about the whole process. So whether to take a plea or not is in the hands of the individual defendant, even if they don't know that. Right now, sort of popular lore is everybody is told that this is just the way it is, and you get charged, and you take a plea, and you move on, and everybody pleads to something. And if we can dispel that rumor just a little bit, if we can convince enough people to at least be suspicious about no-holds-barred plea bargaining, engaging in that whole process. And if we stop thinking that it's the only way to do things or that it's normal for a functioning justice system to act like this, we could probably swing a 10% increase in trials, and it's worth a shot. So I profile people in the book who have organized successful campaigns to change the way that the public thinks about criminal justice. And I hope that you find that interesting. I talk about how they did it, and they're really the protagonists of the book. And so I want to come back in the words that every audience is waiting for on this kind of thing. In closing, I want to come back to, why would you read a book like this, right? Because there's a global pandemic, and there's the rise of fascism, and there's the looming threat of World War III and climate catastrophe and everything else, and people are suffering and dying all over the world, and so why should we? Well, they're suffering and dying here too, right? People are suffering and dying here too, down the street in our jail, and in every community. It's just that we're used to it. We've gotten very accustomed to that way of existing, and many of us don't know any other way, and that's sad. The deaths at this jail down here, you've got, 6 in a 3-month period? And that's not that unusual. People die in jails all the time. People bake to death and they freeze to death. And somebody in Eddyville a couple of years ago starved to death. Can you imagine that? Starving to death in a prison. Die of COVID-19 or heroin withdrawals are very, easily preventable things. And this jail down the road has got space for 2,000 people. And they're almost always overfull by about 500. Almost always. And do we really think that in a community our size that we have that many people that need to be kept away from the rest of us? I don't know the answer to that. I'm not a social worker. Maybe. Maybe we have that many people that need to be sequestered and kept away from society at large. But even if you think that, do we really think that the best place for those people is in cages? Is in like these miniature torture chambers downtown? I have to think that the answer to that is no. And part of my point in this book is that the criminal class is our community. It's a third of us. It could be any of us. You could walk out of here and get arrested for myriad different things, right? Take my card. But it could be any of us. And I think the criminal justice system simply has to change, and we have to figure out a way to do it. We can't just accept it the way it is. We got to try to do something. And so if there's one thing I hope you'll take away from the book, or at least this talk, it's that we don't have to roll over and take it. We don't have to have the worst criminal justice outcomes in the world. We can fight here on the ground for a better legal system and a more humane and just way of dealing with crime. I think we can achieve it. I'll take questions.
Hello, Professor.
Hi.
So what are your thoughts on recidivism in plea bargaining? And before you answer that, I'm going to give you an example. So I have a case, or several cases, with one client who keeps finding themselves back in the same situation, same type of offense based in substance abuse. This person wanted to take a plea offer because they wanted to get out of jail as quickly as possible. They got out of jail, began probation, and caught another similar offense, recidivism, due to substance abuse. And now, because they took that previous probation, the prosecutor wields the hammer over their head
Yeah.
and tries to revoke their probation. But before they do that, they see this second case through where that person then again accepts a second plea deal. So now they're on probation for 2 cases, and the prosecutor waits until this second case where the person has pled guilty, received the second plea offer, to revoke the very first probation. What do you think about recidivism and plea bargaining?
Well, I don't like it. And I don't know. I mean, I don't know how to answer the question. I mean, I think that, the answer ultimately is, as simplistic as it is stop prosecuting people for substance abuse, and this is why I say, it's like, okay, assuming that we're going to crash the system in some way by clogging it up with more and more and more trials, okay, let it crash, right? Let it crash to a certain degree, because there's how are your outcomes going to be any worse if you have more trials? And I think what happens is that you force prosecutors into making screening decisions, like whether or not they're going to prosecute these substance abuse cases or not. And I mean, you have to figure out a way to put pressure on prosecutors. And I don't know any other way to do it besides just up the number of trials, or elect good people into those elected prosecutors' offices. But if you're a deputy, there's just not a whole lot you can do about it. You're going to go with the flow, right? So, I mean, electing new prosecutors is good, but that only tends to last as long as the term of that elected prosecutor. So you have to get people because the legislature's not going to do it. We're not going to have this magic change, to the criminal law, the black letter criminal law overnight. I think you have to put pressure on prosecutors to make different decisions about what cases they prosecute. Sir?
Yes, sir. Great talk. Very enlightening. Among so many points you made, it was for me a revelation that there are so few, I should say, jury trials in this country. I mean, I knew, about a lot of plea bargaining, and I think perhaps that has something to do with, the lack of, the recognition of that, because on television we see so many jury trials.
Yeah.
And it probably gives us the false impression, with all these dramas and dramatizations and re-dramatizations of jury trials, that, people are getting a lot of jury trials. But my question is, when you talk about the lack of jury trials, does that have some correlation to revenue generation? And a lot of this is motivated by putting more fines on people.
You mean in the sense that
in the plea bargaining process,
because you're trying to slap people with fines and
Yes.
move them through. Yeah, no, I think that is. Well, it's all kind of balled up in the whole idea that, I mean, I think a lot of this can be revenue driven. It depends on what the jurisdiction in question is prosecuting for. And I mean, a lot of it is just sort of mean, because that's the mode that we've gotten into, and everybody's just conviction crazed. So we're going to cram as many convictions through. And, part of it is driven by police department quotas, right, which I talk about a little bit in the book. And so, up until, I want to say it was very recently, 2019 maybe, 2018. I don't remember off the top of my head, but there was a huge federal grant that was tied to the number of cases prosecuted by local law enforcement. And so, it just gives everybody a financial incentive to jack up the number of cases that end up in the system. So I think even if there's not a financial incentive by the municipality, there could still be a financial incentive by the police department. But certainly, there's some smaller jurisdiction. I think it's less true in metropolitan areas, but there's certainly some smaller counties, some smaller jurisdictions that they're making all their money off of, I mean, speeding tickets and that kind of thing. But that isn't necessarily even really we're talking more about misdemeanor offenses. And how much money are they really collecting from people on those, from locking them up and convicting them over and over and over again? I don't know what the answer is to that. I think it's probably very little. So.
Thank you for doing this and talking about the history. I wanted to comment a little bit about the Metro Jail. It is, in fact, the second largest lockup facility in Kentucky. It's exceeded by only one state prison. That said, another way to think of it now is if you look at the population of the state reformatory at LaGrange and the women's prison at Pee Wee Valley, and you add that up, there are more people in downtown Metro Jail than both those prisons put together.
Yeah.
That said, the Metro Jail represents 7% of the county jail inmates in Kentucky, only 7%. So what that means is that you have 21,000 people locked up in county jails in Kentucky. 9,000 of those are paying inmates because the state pays those counties to put them in there. 1,800 of those inmates are federal inmates, and they make twice as much money. Inmates have become commodities, and this is something that goes far beyond the 6 deaths at the Metro Jail. This is a great opportunity. How can we call attention to what is really going on?
The question is, how can we call attention to what is really going on? I don't know. I mean, I wrote a book. Maybe you guys heard about it. No, and this is the thing that I tell my law students is that you have to use the media because the courts are not necessarily going to get you anywhere. Like the courts are used to this kind of thing. And if you have been involved in a civil rights practice for as long as I have, even the most egregious things that happen in a jail, even the most egregious things that a police officer can do to somebody, the courts really don't care that much about it. It's like, well, that's the cost of doing business. So we have to find strategies that I mean, for lawyers, what I tell them is that you got to find strategies that don't involve the courts, that involve the media, that involve grassroots organizations, and that are putting pressure from the bottom up. If you look at the Breonna Taylor protests, look, I've been doing this for a while. And Metro government has been tight-fisted about cop death and about jail death and about everything for as long as I've been in practice. You've got to beat money out of them at a jury trial, which, almost never happens because the judges will dismiss the cases, like civil rights cases, before they ever get there. So there's no criminal accountability for anybody who, for cops that just kill people. There's no civil liability for jails that torture people or cops that kill people. And so where's the accountability? Well, I think the accountability happens in the street, because you see them paying out, Breonna Taylor's case, $11 million, only after people were in the streets for 4 months. So, I mean, I think that we've got to look at bottom-up strategies because the top-down strategies are just not gonna happen. And that necessarily involves the media and building coalitions on the ground with grassroots organizations, with churches, with anybody that'll listen. And that's, when you get into the last chapter of this where you talk about the criminal justice organizers that have successfully done that in Wisconsin and in Florida and in New Orleans. They've done tremendous work by doing just that, by building a broad-based coalition on the ground. Sir.
Yes, I wanted to thank you for your talk, and I agree with you 1,000%. I think that plea bargains should be banned on a federal level. I am a criminal. Did 7 calendars in the prisons here in Kentucky. And I can tell you that if any of you all did, you probably stop paying your taxes. You asked us why we should read your book, and I think everybody should read it. And I think the best reason probably would be for self-preservation. And I like your English history, but I'm really more of a fan of the French history. We wouldn't be a country without them.
Yeah, that's in there too.
If you look at what happened with them, right after our revolution in 1789. It seems to be getting to that point here in this country where I think people are just fed up to the point where they're going to break out the guillotine, man. You know, and mass incarceration was one of the reasons why they stormed the Bastille in 1789. It's not something that is sustainable as a nation. We're not going to be able to continue to do this. And I can tell you that I'm a much more dangerous person after being in prison for 7 years. I had to live around murderers that if I didn't learn to get down on their level, I would die. Yeah. So you don't want to create more people like that. And we do that to tens of thousands of people, and you're putting them out on the streets. That's why there's so much violence on the streets. I mean, good God. These people have been locked up probably, and they call it gladiator school, man. You know, that's not smart, man. So self-preservation, just think about that. All of you, it's very unsafe for all of us. I don't want us to have a revolution like that.
Right. Yeah. No. Where is?
So my question is, for you, one question, because you're a lawyer, okay? You got to follow the money, okay? The money, there's a massive amount of money being made by a certain group of people on this mass incarceration, primarily lawyers. How do you feel about a moratorium on law school students graduating from law school, or just simply reducing the number of lawyers in this country?
I don't think that the problem is the number of lawyers that are out there. I think that the problem is that fewer than 2% of us, less than 2% of us, work on legal problems of the poor.
This is probably true.
But it is true.
Isn't there way more lawyers in this country than most other countries?
No, I don't think so. Not per capita. No.
Okay.
No, I don't think so. But I mean, is the problem the way that we're training lawyers to go into the future and what we're training them to do? And is the problem, what lawyers spend their time on? Yeah, listen, you won't get any argument from me on that. Right. Absolutely.
Yeah,
100%.
It's an extortion racket. I mean,
I don't know, folks.
Anybody who's been in the system knows that.
I don't know how close we are to 1789 when we've got
both sides, both parties have rioted.
Folks that will gleefully vote for billionaires who want to take their health care away. But
it's
anyway.
getting pretty bad.
Yeah.
All right, good luck.
Hello.
Hello, how are you?
Good, how are you?
I'm good, thanks. So when you talk about crashing the system, that speaks to my soul.
Yes.
And I love the idea of crashing the system.
I've heard that about you.
Yeah, once or twice. But my question is, in light of the statistic that people on death row are basically penalized for going to trial, are we as lawyers basically using at-risk populations as pawns to do what we think needs to be done in the long term to fix the criminal justice system? Like, how do we balance individual at-risk people? Yeah.
No, I mean, I think that you can't play around with somebody's life because the situation today is what it is. And that's why I emphasize, a swing in 10% of the cases that are being tried, not the death penalty cases that are being tried, right? Because if it becomes a life or death sort of thing, or even a 5 years versus life in prison, you have to,
right.
As a defense attorney, you have to
right.
take that deal, or else it's practically malpractice not to, right? If your client wants it and it's available, you got to do it. But that doesn't mean that you can't, in some other way, swing the number of trials by about 10 or 15%.
Right.
So I'm not saying, the premise of this book is not get rid of plea bargaining. The premise of the book, that sounds nice. It's easier to remember, right? But the premise of the book is more like reduce it by 10 to 20%.
Cool.
And there's lots of different ways to do that.
I think the subheading should be "Let's burn it down."
I ran that past the publisher. I couldn't get it through. Yeah, and that was after all the expletives that I floated too.
You may have just answered my question, but my question was, I heard a lot about what prosecutors are doing to people who've been arrested. What I didn't hear was, where are the public defenders? Where are the people that are supposedly representing these people?
Well-
And why are they not fighting back a little
They
bit?
can't. Yeah, they can't. Well, public defenders will want to answer that question. There's so many of them that are chomping. The prosecutors are all mad at me, and now the public defenders are going to be mad. No, they can't. They can't. If you give somebody, you give a lawyer a caseload of 900 cases, so here, do the best you can, and they can't. A lot of states, in fact, there's a whole chapter on it. A lot of states, in fact, state public defender systems have sued their own states, Kentucky included, because they're committing malpractice per se by, just having the caseloads that they have. So yeah, there's these enormous caseloads because, we're just trying to cram all the convictions that we possibly can into the system. And so if you're a defense attorney, a public defender, and you go in and you say, well, listen, we got to plead as many of these as you can. I'm going to focus on the ones that I think I've got a shot at, taking to trial. And maybe that's like 2% of the cases that I got. Everybody else, I'm just going to get them the best deal they can as quick as I can so I can spend time on the cases that are actually going to trial. And for the private bar, it's an issue of capitalism. You got, up in Indiana, they do public defense a little different. And you've got, in most of Indiana, right, you've got a system where private lawyers are taking all the public defense cases in addition to the private cases that they've already got that are paying them. And they're only going to pay them a certain amount to take those public cases. And so they hit that amount and they're like, well, I'm not making any more money on this. And they'll either ditch the client or take a plea deal real quick. So the private bar has got an issue of capitalism too. So yeah, everybody's complicit in the whole thing. Don't worry, I don't let anybody off, not even me. Oh, yeah, and that means I'm done.
Thank you very much.
Thank you all.
We'll be signing books at the back too.
Thanks very much.